Paper, Land Laws 1 Question 1, Grounds for eviction of a tenant under Rajasthan Rent Control Act, 2001. What are the various grounds for eviction of a tenant under the Rajasthan Rent Control Act, 2001? Legal framework of the Rajasthan Rent Control Act, 2001. The Act, effective from April 1, 2003, aims to control eviction, regulate rent, and facilitate dispute resolution through specialized tribunals. Unlike its predecessor, the Act restricts eviction to specific grounds enumerated in Section 9, ensuring tenants are protected from arbitrary dispossession while allowing landlords to recover their property under justifiable circumstances. The Rent Tribunal, constituted under Section 13, has exclusive jurisdiction over disputes between landlords and tenants, superseding civil courts for matters covered under the Act. 1. Section 15 outlines the procedure for eviction, mandating a summary inquiry and a time-bound resolution, typically within 245 days from the service of notice. 4. The Act defines key terms in Section 2, such as landlord, a person entitled to receive rent; tenant, a person who pays or is liable to pay rent; and premises, a building or part thereof let for residential, commercial, or other purposes, including appurtenant land and amenities. These definitions clarify the scope of the Act and the parties involved in eviction proceedings. The grounds for eviction under Section 9 are exhaustive, and landlords must prove one or more of these grounds to obtain an eviction order, ensuring a balance between tenant security and landlord rights. 7. Grounds for eviction under Section 9. Section 9 of the Act specifies the conditions under which a rent tribunal may order the eviction of a tenant. These grounds are designed to protect tenants from arbitrary eviction while allowing landlords to reclaim their property for legitimate reasons. The following subsections detail each ground, supported by examples and case law where applicable. Non-payment of rent under Section 9. A. A tenant may be evicted if they have neither paid nor tendered the rent due for 4 months, provided the landlord has disclosed their bank account details in the rent agreement or via a registered notice. The landlord must serve a notice demanding arrears, and eviction proceedings can only be initiated if the tenant fails to pay within 30 days of receiving the notice. 7. The rent is deemed tendered if remitted through a money order or deposited with the rent authority. 7. Example: if a tenant in Jaipur fails to pay rent for 4 months despite receiving a registered notice from the landlord specifying the bank account for payment, the landlord can file a petition before the rent tribunal. The tribunal will conduct a summary inquiry and may issue a certificate for recovery of possession if the tenant's default is established. Case law: in Harbans Kaur v. Iqbal Singh, 2019 SCC Online SC 94, the Supreme Court emphasized the importance of adhering to procedural requirements under the Act, such as serving a proper notice for arrears, to ensure fairness in eviction proceedings based on non-payment. 13. 2. Substantial damage to premises. Section 9, b, allows eviction if the tenant has willfully caused or permitted substantial damage to the premises. This ground protects the landlord's property from deliberate or negligent harm by the tenant. Example: if a tenant in a commercial property in Udaipur modifies the structure by breaking walls without permission, causing significant damage, the landlord can seek eviction. The tribunal will assess whether the damage is substantial and willful. Case law: while specific cases under the Act are limited, the principle is analogous to Madan Lal v. Hemawati, ILR 1970 Delhi 519, where damage to property was a valid ground for eviction under the Delhi Rent Control Act, highlighting the need for evidence of willful intent. 12. Unauthorized construction or alteration under Section 9, c. Eviction is permissible if the tenant has made or permitted unauthorized construction that materially alters the premises or diminishes its value without the landlord's written consent. Example: a tenant in Jodhpur constructs an additional room in a rented residential property without the landlord's permission, altering the building's structure. The landlord can approach the rent tribunal, which will evaluate the extent of alteration and its impact on the property's value. Case law: the principle is supported by Akintya Kumar Saha v. Naini Printers, 2004, 12 SCC 368, where unauthorized construction was a ground for eviction under rent control laws, emphasizing the need for written consent. 10. Creation of nuisance or adverse use. Section 9, d, permits eviction if the tenant has created a nuisance or engaged in acts inconsistent with the purpose of the tenancy, adversely affecting the landlord's interests. Example, a tenant operating a noisy workshop in a residential premises in Kota, disturbing neighbors, may face eviction. The tribunal will determine if the tenant's actions constitute a nuisance or violate the tenancy's purpose. Case law, in Ramnarayan v. Lakshmi Das Kundra, Air 1971 Delhi 268, the court upheld eviction for nuisance under similar provisions, noting that tenant activities must align with the agreed purpose of the lease. 12. Unauthorized subletting or assignment. Section 9, e, allows eviction if the tenant has assigned, sublet, or parted with possession of the premises without the landlord's written permission. Example, if a tenant in Ajmer sublets a portion of the rented shop to another business without the landlord's consent, the landlord can seek eviction. The tribunal will verify the absence of written permission and the extent of subletting. Case law, the Supreme Court in Vidhanapal Chettiar v. Yezideh Amal, Air 1979 SC 1745, clarified that unauthorized subletting is a valid ground for eviction under rent control laws, provided 3. the landlord proves the Act. 12. Cessation of employment-based tenancy. Under Section 9, h, eviction is permitted if the premises were let for residential purposes due to the tenant's employment with the landlord, and the tenant has ceased such employment. Example, a company in Bikaner provides housing to an employee as part of their employment contract. If the employee resigns and continues to occupy the premises, the landlord can seek eviction. Case law, while specific cases under this provision are scarce, the principle aligns with employment-based tenancy cases under other rent control laws, where cessation of employment terminates the tenancy. Bona fide requirement of the landlord. Section 9, I, allows eviction if the landlord reasonably and bona fide requires the premises for their own use, their family's use, or for someone for whose benefit the premises are held. The landlord is prohibited from reletting the premises to another person within 3 years, and the tenant may seek restoration if this condition is violated. 7. Example, a landlord in Jaipur requires the rented shop for their son's new business. They must demonstrate to the tribunal that the need is genuine and not a pretext for eviction. Case law, in Ravi Khandelwal v. Talika Stores, 2023. Latest case law 561 SC, the Supreme Court upheld eviction based on the landlord's bona fide need, emphasizing that the landlord's intent must be genuine and not mala fide. 9. Similarly, in Shankar Lal Nadani v. Sahan Lal Jain, 2022. Latest case law 307 SC, the court clarified that the landlord's need must be reasonable and supported by evidence. 9. Procedural aspects of eviction. The eviction process under the Act is governed by Section 15, which ensures a streamlined and time-bound procedure. The landlord must file a petition before the rent tribunal, which issues a notice to the tenant via registered post or process server. 4. The tenant may file a reply, followed by a rejoinder from the landlord, within specified timelines. The tribunal conducts a summary inquiry, aiming to dispose of the petition within 245 days. If the tribunal rules in favor of the landlord, it issues a certificate for recovery of possession, appealable before the appellate rent tribunal. 1. The Act also allows tenants to seek restoration of possession under Section 16 if they were illegally dispossessed without due process. The tribunal may order immediate restoration and award compensation for hardship. 4. This provision underscores the Act's commitment to protecting tenants from unlawful evictions. For judicial interpretations and leading cases, the judiciary has played a crucial role in interpreting the Act, ensuring its provisions are applied fairly. Key cases include, Ravi Khandelwal v. Talika Stores, 2023. Latest case law 561 SC. This case clarified the scope of bona fide requirement under Section 9, I. The Supreme Court held that the landlord's need must be genuine, and the tribunal must assess the reasonableness of the claim based on evidence. 9. Harbonskar v. Iqbal Singh, 2019 SCC Online SC 94. The Supreme Court emphasized the procedural safeguards under Section 9(a), requiring landlords to provide clear notice of arrears and bank details to initiate eviction proceedings. 13 Martin and Harris Private Limited v. Rajendra Mehta, 2022. Latest case law 504 SC. This case addressed the balance between landlord and tenant rights, reinforcing that eviction grounds must be strictly construed to prevent abuse. 9 Badra Lal v. Kishan Lal. Case 9. The court clarified that once the act applies to an area, eviction must comply with Section 9, and civil courts lose jurisdiction. 14. These cases highlight the judiciary's role in ensuring that eviction proceedings adhere to the Act's provisions, balancing the interests of both parties. Comparative analysis with other rent control laws. The Rajasthan Rent Control Act, 2001, differs from other state laws, such as the Delhi Rent Control Act, 1958, or the Karnataka Rent Control Act, in its emphasis on tribunal-based dispute resolution and specific procedural timelines. For instance, the Delhi Act allows eviction for non-payment of rent after 2 months of arrears. 12, whereas the Rajasthan Act requires 4 months. 7. The Karnataka Act includes broader grounds, such as unauthorized use, but shares similarities in requiring legal notice. 11. These differences reflect regional variations in addressing landlord-tenant disputes. Challenges and criticisms. Despite its progressive framework, the Act faces challenges. Tenants often exploit procedural delays, prolonging eviction proceedings, as noted in Ravi Khandelwal v. Talika Stores. 9. Landlords may face difficulties proving bona fide need, especially if tenants challenge the genuineness of the claim. Additionally, the requirement for written consent for subletting or alterations can lead to disputes if agreements are poorly documented. Strict implementation of the Act, as suggested in legal commentary, is essential to ensure its effectiveness. 13. 5. Question 2. Limited period tenancy and modes of execution of orders under Rajasthan Rent Control Act, 2001. Write short notes on a. Limited period tenancy under Rajasthan Rent Control Act, 2001. b. Modes of execution of orders under Rajasthan Rent Control Act, 2001. Limited period tenancy under the Rajasthan Rent Control Act, 2001. Defining limited period tenancy. Limited period tenancy, as provided under Section 6 of the Rajasthan Rent Control Act, 2001, refers to a tenancy created for a specific duration through a written agreement between the landlord and tenant. Unlike standard tenancies, which may continue indefinitely unless terminated under specific grounds, a limited period tenancy is characterized by its predetermined term, agreed upon at the outset of the lease. The Act mandates that such tenancies be formalized in writing and registered under the Registration Act, 1908, to ensure legal enforceability. 4. Upon the expiry of the agreed period, the tenancy terminates automatically, and the landlord is entitled to recover possession without invoking the eviction grounds under Section 9, provided the agreement complies with the Act's requirements. The concept of limited period tenancy is designed to provide flexibility to both parties, allowing landlords to lease premises for a fixed term without long-term commitments and offering tenants clarity on the duration of their occupancy. Section 6, 2, specifies that such tenancies are exempt from the eviction restrictions under Section 9, meaning the landlord does not need to prove grounds like non-payment of rent or bona fide requirement to recover possession at the end of the term. 7. However, the agreement must explicitly state the duration and be executed in accordance with legal formalities. Key features and requirements. The Act imposes specific requirements for a valid limited period tenancy. Written agreement. The tenancy must be documented in a written lease agreement, specifying the duration of the tenancy. Registration. The agreement must be registered under the Registration Act, 1908, to be legally enforceable. Non-registration may render the tenancy subject to the Act's general provisions, including eviction restrictions. Mutual consent. The duration and terms must be mutually agreed upon by the landlord and tenant, ensuring clarity and transparency. Exemption from Section 9. Upon expiry, the landlord can recover possession without proving any ground under Section 9, provided the agreement is valid and registered. 7. 6. If the tenant continues to occupy the premises after the expiry of the term without the landlord's consent, they become a tenant by sufferance, liable to eviction through the rent tribunal. 1. The tribunal may issue a certificate for recovery of possession under Section 15, following a summary inquiry. Practical example: consider a scenario in Jaipur where a landlord leases a commercial shop to a tenant for a fixed term of 2 years, formalized through a registered lease agreement under Section 6. The agreement specifies that the tenancy will terminate on December 31, 2025. Upon expiry, the landlord serves a notice to the tenant to vacate the premises. If the tenant refuses, the landlord can file a petition before the rent tribunal, which will verify the validity of the registered agreement and issue a certificate for recovery of possession without requiring proof of eviction grounds under Section 9. This streamlined process underscores the efficiency of limited period tenancies for landlords seeking to reclaim their property at the end of a fixed term. Judicial interpretation: the judiciary has clarified the scope and application of limited period tenancies in several cases. In Ravi Khandelwal v. Talika Stores, 2023 latest case law 561 SC, the Supreme Court emphasized that a valid limited period tenancy, duly registered, exempts the landlord from proving eviction grounds under the Act, provided the agreement complies with statutory requirements. 9. The court held that non-registration of the lease agreement could negate the benefits of Section 6, subjecting the tenancy to the Act's general eviction provisions. Another relevant case is Badra Lal v. Kishan Lal, case 9, where the Rajasthan High Court ruled that a limited period tenancy terminates automatically upon expiry, and the tenant cannot claim protection under Section 9 unless the agreement is defective or unregistered. 14. These judicial pronouncements underscore the importance of adhering to procedural formalities to ensure the enforceability of limited period tenancies. Challenges and considerations: despite its advantages, limited period tenancy poses challenges. Tenants may attempt to extend their occupancy by challenging the validity of the lease agreement or alleging coercion in its execution. Landlords must ensure that the agreement is clear, registered, and free from ambiguities to avoid disputes. Additionally, the requirement for registration under the Registration Act, 1908, may impose financial and procedural burdens, particularly for small-scale landlords. 13. The judiciary has consistently emphasized strict compliance with these requirements to uphold the sanctity of limited-period tenancies. 7. Modes of execution of orders under the Rajasthan Rent Control Act, 2001. Overview of execution mechanism. Section 20 of the Rajasthan Rent Control Act, 2001, governs the execution of orders passed by the Rent Tribunal or Appellate Rent Tribunal. The Act establishes a specialized mechanism to ensure that orders, such as those for eviction or recovery of rent, are enforced efficiently, minimizing delays associated with traditional civil court processes. The execution process is designed to be summary in nature, aligning with the Act's objective of providing speedy justice to landlords and tenants. 1. Orders issued by the tribunal, such as certificates for recovery of possession or payment of arrears, are executed as if they were decrees of a civil court, with specific procedures outlined to ensure compliance. Key modes of execution. The Act provides for the following modes of execution under Section 20. 1. Execution as a civil court decree. Section 20, 1, stipulates that an order of the Rent Tribunal or Appellate Rent Tribunal is executed in the same manner as a decree of a civil court under the Code of Civil Procedure, 1908, CPC. The tribunal may forward the order to a civil court with jurisdiction for execution, particularly if the order involves recovery of possession or payment of money for. 2. Recovery of possession. If the tribunal issues a certificate for recovery of possession under Section 15, e.g., for eviction due to non-payment of rent or expiry of a limited period tenancy, the landlord can apply to the tribunal or civil court for enforcement. The executing authority may employ measures such as forcible eviction, with assistance from law enforcement if necessary. 7. 3. Recovery of arrears of rent. For orders directing payment of rent arrears, the tribunal may issue a recovery certificate, which is executed through attachment and sale of the tenant's movable or immovable property, as per CPC Provisions 1. For restoration of possession, under Section 16, if a tenant is illegally dispossessed, the tribunal may order immediate restoration of possession. The execution of such an order may involve directing the landlord to vacate the premises and restore the tenant, with compensation for hardship if applicable. 4. 5. Assistance of police or local authorities, in cases of resistance to execution, such as a tenant refusing to vacate, the tribunal or executing court may seek police assistance to enforce the order, ensuring compliance without undue delay. 13. Procedural aspects. The execution process begins with the issuance of a final order by the rent tribunal or appellate rent tribunal. The landlord or tenant, depending on the order, files an application for execution, 8 specifying the mode of enforcement, e.g., recovery of possession or attachment of property. The tribunal or civil court verifies the order and issues a warrant or notice to the party against whom execution is sought. The CPC provisions, particularly Order XXI, govern the procedural aspects, such as notice to show cause, attachment of property, or delivery of possession. 7. The Act emphasizes time-bound execution to prevent delays. For instance, the tribunal is required to dispose of execution applications expeditiously, typically within a few months, to uphold the Act's objective of speedy justice. 1. If the tenant obstructs execution, the tribunal may impose penalties or seek assistance from local authorities to enforce the order. Practical example: suppose a landlord in Jodhpur obtains a certificate for recovery of possession from the rent tribunal due to the tenant's non-payment of rent for 4 months under Section 9(a). The tenant refuses to vacate the premises despite the order. The landlord files an execution application under Section 20, requesting delivery of possession. The tribunal forwards the certificate to a civil court, which issues a warrant for possession. If the tenant resists, the court may direct the local police to assist in evicting the tenant and restoring possession to the landlord. Alternatively, if the order involves recovery of rent arrears, the court may attach the tenant's bank account or other assets to satisfy the debt. Judicial interpretation. Judicial decisions have clarified the execution process under the Act. In Martin and Harris Private Limited v. Rajendra Mehta, 2022 latest case law 504 SC, the Supreme Court emphasized that execution of rent tribunal orders must adhere to CPC provisions, ensuring procedural fairness while maintaining efficiency. 9. The court noted that delays in execution undermine the Act's purpose and directed tribunals to prioritize timely enforcement. In Shankar Lal Nadani v. Sahan Lal Jain, 2022 latest case law 307 SC, the Rajasthan High Court addressed resistance to execution, holding that police assistance is permissible under Section 20 to enforce eviction orders, provided due process is followed. 9. Similarly, in Badra Lal v. Kishan Lal, case 9, the court clarified that execution of tribunal orders supersedes civil court jurisdiction, reinforcing the Act's specialized framework. 14. Challenges and considerations. The execution process, while streamlined, faces challenges such as tenant resistance, procedural delays in civil courts, or disputes over the validity of tribunal orders. Tenants may file frivolous appeals to delay execution, as noted in Ravi Khandelwal v. Talika Stores 9. Additionally, the reliance on CPC provisions may introduce complexities, particularly for landlords unfamiliar with civil court procedures. Legal scholars suggest that enhancing tribunal powers to directly enforce orders could further streamline the process. 13. 9. Question 3. Lands where Khattari rights shall not accrue under Rajasthan Tenancy Act. In which lands, Khattari rights shall not accrue under Rajasthan Tenancy Act? Explain. Khattari rights, an overview. Khattari rights, as defined under Section 15 of the Act, are conferred upon tenants who, at the commencement of the Act, were cultivating land, other than as subtenants or tenants of Khud Kasht, or who were subsequently admitted as tenants or allotted land under the Rajasthan Land Revenue Act, 1956, or other applicable laws. These rights include the right to use and cultivate the land, heritable and transferable interests, subject to restrictions under Section 43, protection against arbitrary eviction, the ability to make improvements and claim compensation for the same. However, Section 16 imposes a statutory bar on the accrual of these rights in specific categories of land, ensuring that certain lands remain outside the ambit of private tenancy rights. This restriction is rooted in the state's authority as the ultimate owner of agricultural land, as reaffirmed in judicial pronouncements such as Kaluram v. State, Rajasthan High Court. Lands where category rights do not accrue. Section 16 of the Rajasthan Tenancy Act, 1955, explicitly states that notwithstanding anything in this act or in any other law or enactment for the time being in force in any part of the state, category rights shall not accrue in the following categories of land. These categories are designed to protect public interests, preserve communal resources, and uphold specific legal or traditional arrangements. Pasture land, designated for grazing and communal use, is excluded from category rights to ensure its availability for livestock and community needs. The Act recognizes the importance of such lands in Rajasthan's agrarian economy, where cattle rearing is a significant livelihood source. Allowing category rights on pasture land could lead to its privatization, undermining communal access. Example, in a village in Jaisalmer, a tenant cultivating pasture land claimed category rights under Section 15. The Revenue Court, citing Section 16, rejected the claim, emphasizing that pasture land is reserved for communal use and cannot be converted into private tenancy land. 10. Land used for casual cultivation in river or tank beds. Lands used for casual or seasonal cultivation in riverbeds or tank beds are excluded due to their temporary and fluctuating nature. These lands are often submerged during monsoons, making permanent tenancy impractical. The exclusion ensures that such lands remain available for seasonal use without conferring permanent rights. Example, in Mamraj v. Sitaram, Rajasthan High Court, the court held that a tenant cultivating land in the Chambal riverbed could not claim category rights due to the statutory bar under Section 16, as the land was subject to seasonal flooding and designated for casual cultivation. Land allotted temporarily in specific project areas. Section 15's proviso, reinforced by Section 16, specifies that no category rights accrue to tenants holding land temporarily in areas such as the Gang Canal, Bakra, Chambal, Jawai, or other notified project areas. These areas, developed for irrigation and agricultural projects, are subject to state control to ensure equitable land distribution and prevent permanent tenancy claims that could disrupt project objectives. Case reference, in State of Rajasthan v. Ghanchamdas, Rajasthan High Court, 1961, the court upheld that category rights could not accrue in land allotted in the Rajasthan Canal area, as it was deemed temporarily leased under the Rajasthan Colonization Act, 1954. The court emphasized that Section 16 and the proviso to Section 15 prioritize state control over project lands to facilitate planned development. Land belonging to minors, lunatics, or religious institutions. Section 46 of the Act, read with Section 16, prohibits the conferment of category rights on lands held by minors, persons of unsound mind, or religious institutions, e.g., temples or deities. This provision protects the interests of vulnerable groups and sacred lands by preventing tenants from claiming permanent rights over such properties. Leading case, Murti Mandir Shri Nyamaji Laxmangar v. State of Rajasthan, 2008, the Rajasthan High Court held that a deity, considered a perpetual minor, cannot have its land subject to category rights. The court ruled that tenants cultivating temple land, Mandir Mayfi land, are deemed subtenants, and no category rights can accrue under Section 16. This decision reinforced the principle that sacred lands are inalienable, protecting the deity's perpetual ownership. Recent case, Sri Gopalji Temple case, 2025, in a recent ruling, land belongs to deity, Rajasthan High Court, 2025, the court dismissed a 35-year-old plea claiming category rights over temple land, citing sections 19 and 46. The court reiterated that the deity, as a perpetual minor, retains ownership, and cultivation by tenants does not confer category rights. 6. Land allotted to village servants under section 193, category rights may be conferred on village servants whose services are no longer required, but such rights do not accrue during their tenure. This ensures that lands allocated for village services remain tied to their intended purpose. 11 Example, a village watchman cultivating land allotted for his service claimed category rights. The Revenue Court rejected the claim, citing section 16, as the land was designated for village service and not for permanent tenancy. Other lands specified by law. Section 16 also encompasses lands excluded under other laws, such as the Rajasthan Land Reforms and Resumption of Jagirs Act, 1952, or the Rajasthan Colonization Act, 1954. For instance, lands in the Indira Gandhi Canal area are deemed temporarily leased, and no category rights accrue unless expressly provided under specific colonization rules. 1. Judicial interpretations and leading case analysis. The judiciary has played a crucial role in interpreting Section 16, clarifying the scope of category rights and their exclusions. The landmark case of State of Rajasthan v. Ghanshyamdas, Rajasthan High Court, 1961, is pivotal in this context. Case analysis. State of Rajasthan v. Ghanshyamdas. In this case, the respondents were allotted land in the Rajasthan Canal area under the Rajasthan Colonization Act, 1954. They claimed category rights under Section 15 of the Rajasthan Tenancy Act, arguing continuous cultivation. The Tehsildar initially conferred category rights, but the state challenged this before the Rajasthan High Court. The court set aside the Tehsildar's order, holding that lands in the Rajasthan Canal area are deemed temporarily leased under the proviso to Section 15 and Section 16. The Rajasthan Colonization Act's rules override general tenancy provisions, prioritizing state control for planned agricultural development. Category rights cannot accrue in project areas unless explicitly provided by colonization rules. 5. This decision established that state development objectives take precedence over individual tenancy claims in designated project areas, reinforcing the statutory bar under Section 16. Other relevant cases. Kaluram v. State, Rajasthan High Court. The court ruled that adverse possession cannot confer category rights in lands statutorily barred under Section 16, such as those in the Chumbal project area, emphasizing the state's ultimate ownership. 5 Air 1995, Supreme Court 398, the Supreme Court clarified that category rights, while proprietary, are limited and do not confer full ownership, thus excluding CO sharers from claiming preemption rights on their transfer. 3. 12 Jiwan Ram v. Lichma Devi, 1980. The Rajasthan High Court held that agricultural land, including category land, is excluded from preemption under Section 22 of the Hindu Succession Act, reinforcing the limited nature of category rights. 8. Legal rationale and policy implications. The exclusions under Section 16 reflect a deliberate policy to balance tenant protections with public and communal interests. The rationale includes public interest. Lands in irrigation projects, e.g., Indira Gandhi Canal, are critical for state-yield development, requiring flexible control to prevent permanent tenancy claims. Communal welfare. Pasture lands and riverbeds serve communal purposes, and their privatization would disrupt traditional agrarian practices. Protection of vulnerable groups, excluding lands of minors and deities safeguards their interests, preventing exploitation by tenants. Administrative efficiency. Temporary allotments in project areas ensure efficient land management for large-scale agricultural schemes. However, these exclusions have faced criticism for limiting tenant rights, particularly in project areas where long-term cultivation may create equitable claims. The judiciary, as seen in State of Rajasthan v. Ghanshyamdas, has upheld the state's authority, prioritizing development over individual claims. Critical analysis. While Section 16 serves legitimate state objectives, its broad exclusions can disproportionately affect tenants who invest labor and resources in cultivating excluded lands. The blanket prohibition in project areas, for instance, may overlook genuine claims of long-term cultivators. Moreover, the lack of clear timelines for temporary allotments can create uncertainty, as seen in cases like Mamraj v. Sitaram. The judiciary's strict interpretation, while legally sound, may not always account for equitable considerations. For example, in Sri Gopalji Temple case, 2025, the court's emphasis on the deity's perpetual minority protected sacred land but left cultivators without recourse. A potential reform could involve limited tenancy rights or compensation mechanisms for such tenants, balancing state and individual interests. 13. Question 4. Land and landless laborer under Rajasthan Tenancy Act, 1955. Short notes on a. Land according to Rajasthan Tenancy Act, 1955. b. Who is landless laborer under Raj Tenancy Act, 1955. Short note on land under the Rajasthan Tenancy Act, 1955. Statutory definition. Section 5, 24, of the Rajasthan Tenancy Act, 1955, defines land as, land means land which is let or held for agricultural purposes or for purposes subservient to agriculture or for pasture, and includes, 1. The sites of buildings and other structures on such land. 2. Trees standing on such land. 3. Wells, tanks, channels, and other works for the supply or storage of water for agricultural purposes or for purposes subservient thereto. 4. Any right or easement in or over such land or appertaining thereto, but does not include land held under a grant from the state government for residential or commercial purposes. This definition is expansive, encompassing not only land used for cultivation but also ancillary structures, resources, and rights essential to agricultural activities. The exclusion of land granted for residential or commercial purposes ensures that the Act's provisions apply primarily to agrarian contexts. 1. Scope and components. The definition of land under Section 5, 24, includes several components: agricultural and allied purposes, land used for cultivation, pasture, or purposes subservient to agriculture, e.g., storage of crops, cattle sheds, qualifies as land. This broad scope ensures that all activities integral to farming are covered. Structures and sites. The sites of buildings, e.g., farmhouses, and structures, e.g., barns, on agricultural land are included, recognizing their role in supporting farming activities. Natural and man-made resources, trees, wells, tanks, and irrigation channels are explicitly included, reflecting their importance in Rajasthan's arid agrarian economy. Rights and easements. Any rights or easements, e.g., right-of-way for irrigation, over such land are covered, ensuring that legal interests tied to agricultural land are protected. Exclusion of non-agricultural grants. Land granted by the state for residential or commercial purposes is excluded, limiting the Act's application to agricultural contexts. 14. Judicial interpretation. The judiciary has played a crucial role in interpreting the definition of land, particularly in resolving disputes over its scope. The leading case of State of Rajasthan v. Gotharam, Rajasthan High Court, 1969, is illustrative. Case analysis. State of Rajasthan v. Gotharam, 1969, in this case, the respondent claimed Khatri rights over a plot containing a well and a small structure used for storing agricultural tools, arguing that it constituted land under Section 5, 24. The state contended that the plot was primarily used for non-agricultural purposes and thus fell outside the Act's ambit. The Rajasthan High Court held that, the presence of a well and a structure subservient to agriculture, tool storage, brought the plot within the definition of land under Section 5, 24. The primary use of the land, rather than its incidental features, determines its classification. Since the plot supported agricultural activities, it qualified as land 5. This decision clarified that ancillary structures and resources integral to agriculture are included in the definition, even if they dominate the land's physical features. Other relevant cases: Ram Narayan v. State of Rajasthan, Rajasthan High Court, 1972. The court held that barren land held for future agricultural use qualifies as land, emphasizing the potential use over current activity. 5. Air 1985. Rajasthan 77. The court ruled that land with irrigation channels serving multiple agricultural plots is covered under Section 5(24), reinforcing the inclusion of water management infrastructure. 3. Examples: a farmer in Jaipur cultivates wheat on a plot with a small farmhouse and a well for irrigation. The entire plot, including the farmhouse and well, constitutes land under Section 5(24), due to its agricultural purpose. In Jodhpur, a tenant grazes cattle on designated pasture land with a water tank. The pasture, tank, and grazing rights are included in the definition of land. A plot in Udaipur granted by the state for a commercial shop is excluded from the definition, as it is not held for agricultural purposes. Critical analysis: the definition of land under Section 5(24) is comprehensive, ensuring that all aspects of agricultural activity are regulated under the Act. However, its exclusion of residential and commercial grants can create challenges in mixed-use scenarios, where land may serve both agricultural and non-agricultural purposes. The judiciary's focus on primary use, as seen in State of Rajasthan v. 15 Goturam, provides clarity but may overlook nuanced cases where agricultural use is secondary. A potential reform could involve a more flexible classification system to address such ambiguities while maintaining the Act's agrarian focus. Short note on landless laborer under the Rajasthan Tenancy Act, 1955. Statutory definition: Section 5(22)(a) of the Rajasthan Tenancy Act, 1955, defines a landless laborer as a person who is a resident of Rajasthan, is not a minor or a lunatic, and who earns his livelihood principally by manual labor in agriculture or in any activity connected with or incidental to agriculture, and who does not hold any land in his own name or in the name of any member of his joint family, or is not a tenant or subtenant of any land except the land allotted to him under any law for the time being in force. This definition identifies a socio-economically vulnerable group dependent on agricultural labor but lacking land ownership or tenancy rights, making them eligible for land allotment under state schemes. 1. Essential elements: the definition of a landless laborer comprises several key elements. Residency: the person must be a resident of Rajasthan, ensuring that state resources benefit local communities. Competency: the individual must not be a minor or a lunatic, ensuring legal capacity to hold land. Livelihood source: the person's primary livelihood must derive from manual labor in agriculture or allied activities, e.g., cattle rearing, farm maintenance. Landlessness: the individual must not hold land in their name or that of their joint family, nor be a tenant or subtenant, except for land allotted under specific laws, e.g., Rajasthan Land Revenue Act, 1956. Purpose and policy context: the inclusion of landless laborer in the Act reflects Rajasthan's commitment to land reforms aimed at uplifting marginalized agricultural workers. By identifying landless laborers, the state facilitates their access to land through allotment schemes, such as those under the Rajasthan Land Revenue Act, 1956, or the Rajasthan Colonization Act, 1954. This aligns with the broader objective of reducing rural poverty and promoting equitable land distribution. 2. 16. Judicial interpretation: the judiciary has clarified the scope of landless laborer in several cases, with Mang v. State of Rajasthan, Rajasthan High Court, 1975, being a leading precedent. Case analysis: Mang v. State of Rajasthan, 1975. In this case, the petitioner, a manual laborer in a village in Bikaner, applied for land allotment as a landless laborer under a state scheme. The revenue authorities rejected his application, arguing that he occasionally worked as a carpenter, suggesting his livelihood was not primarily agricultural. The Rajasthan High Court overturned the decision, holding that the term principally by manual labor in agriculture under Section 5(22)(a) does not require exclusive reliance on agricultural labor. Occasional non-agricultural work does not disqualify a person if their primary livelihood is agricultural. the petitioner's lack of land ownership or tenancy rights qualified him as a landless laborer, entitling him to allotment 5. This ruling emphasized a liberal interpretation of the definition to ensure that genuinely landless agricultural workers benefit from state schemes. Other relevant cases: Banwar Lal v. State of Rajasthan, Rajasthan High Court, 1980. The court held that a person holding a small, non-agricultural plot, e.g., for a house, may still qualify as a landless laborer if they lack agricultural land. 5 Air 1990 Rajasthan 90. The court clarified that land allotted under a state scheme does not disqualify a person from being a landless laborer for future allotments, as such land is explicitly excluded under Section 5(2)(2)(a), 3. Examples: 1. A resident of Alwar, Ramu, earns his livelihood by working as a farm laborer and occasionally as a cattle herder. He owns no land and is not a tenant. Ramu qualifies as a landless laborer under Section 5(2)(2)(a). 2. In Barmer, Shanti, a widow, supports her family by manual labor in wheat fields. Her joint family owns no agricultural land. She is eligible for land allotment as a landless laborer. 3. A person in Jaipur owning a small commercial plot for a shop but working primarily as an agricultural laborer may still qualify as a landless laborer, as the commercial plot is irrelevant under Section 5(2)(2)(a). Critical analysis: the definition of landless laborer is progressive, targeting a vulnerable group for land reform benefits. However, its implementation faces challenges, such as bureaucratic delays and disputes over livelihood sources, as seen in Mangu v. State of Rajasthan. The requirement of exclusive 17 landlessness may also exclude marginal farmers with minimal holdings, who are equally in need of support. A broader definition, encompassing those with negligible land holdings, could enhance the Act's inclusivity while maintaining its focus on landless workers. 18. Question 5. Powers of Revenue Board and Power of Reference of High Court under Raj. Revenue Act, 1956. Write short notes on a. What are the power of Revenue Board under Raj? Revenue Act, 1956. b. Power of Reference of High Court. Powers of the Revenue Board under Rajasthan Land Revenue Act, 1956. The Revenue Board, established under the Rajasthan Land Revenue Act, 1956, serves as the apex revenue court in Rajasthan, wielding extensive judicial and administrative powers to ensure effective land administration and dispute resolution. Section 9 of the Act outlines the board's role as the highest revenue court of appeal, revision, and reference, subject to the provisions of the Act, the Rajasthan Tenancy Act, 1955, and other applicable laws. Below is a comprehensive analysis of the board's powers, supported by statutory provisions and judicial precedents. Appellate jurisdiction. The Revenue Board exercises appellate jurisdiction over decisions from subordinate revenue courts, as provided under Sections 75 and 76 of the Act. Section 75 allows appeals from original decrees or orders of revenue courts, while Section 76 specifies second appeals to the board in cases involving substantial questions of law. For instance, under Section 76, d. second appeals may be filed against orders passed by the Commissioner, Revenue Appellate Authority, or Settlement Commissioner. Example, in the case of Board of Revenue for Rajasthan v. Rao Baldio Singh, 1967, the Supreme Court examined the board's appellate jurisdiction under Section 76. The dispute involved a claim over agricultural land, where the board overturned a lower court's decision on the grounds of a substantial question of law regarding the interpretation of tenancy rights. The court upheld the board's authority to intervene when lower courts misinterpret legal provisions, reinforcing the board's role as a corrective appellate body. 1 Revisional powers. Section 83 of the Act empowers the board to call for records of any judicial or settlement-related case where no appeal lies, provided the subordinate court or officer has exercised jurisdiction not vested by law, failed to exercise vested jurisdiction, or acted illegally or with material irregularity in exercising jurisdiction. 1 Indian Qanun, Board of Revenue for Rajasthan v. Rao Baldio Singh, 1967, 19 The board may pass appropriate orders to rectify such errors. However, Section 8.4a restricts revisions against interim orders, ensuring procedural efficiency. Case study, in Harji v. Revenue Board of Rajasthan, 1952, the board exercised its revisional powers under Section 83 to review a reinstatement order under the Rajasthan Protection of Tenants Ordinance, 1949. The board set aside the order due to jurisdictional overreach by the subdivisional officer, but the High Court later clarified that the board's revisional powers must align with statutory limits and cannot override established legal principles. Point 2 Reference jurisdiction under Section 11. The board may refer questions of law, custom, or document construction to a division bench for opinion, ensuring consistency in legal interpretations. Additionally, Section 12 allows a bench to refer questions of public importance to the High Court, which is discussed in detail in the next section. Example, in a hypothetical scenario, if a single member of the board encounters a dispute over the customary right to graze cattle on common land, they may refer the matter to a division bench under Section 11 to ascertain the legal validity of the custom, ensuring a uniform ruling. Administrative powers Section 9.2 vests the board with general superintendence and control over all revenue courts and officers, making them subordinate to the board. This includes the power to transfer cases between revenue courts, Section 221 of the Rajasthan Tenancy Act, 1955, read with the Act, and to review its own orders under specific circumstances. Critical analysis, in Surendra Singh v. Kisturi, Rajasthan High Court, the court clarified that the board's administrative powers under Section 221 of the Rajasthan Tenancy Act are distinct from the High Court's supervisory powers under Article 227 of the Constitution. The board cannot set aside judicial orders under its administrative authority, highlighting a clear demarcation between judicial and administrative functions. Point 3 Rule-making powers under Section 261, the board, with the state government's approval, can make rules to regulate revenue court procedures, partition of estates, and other administrative matters. Examples include the Rajasthan Revenue Courts Manual, 1956, and the Rajasthan Land Revenue, Partition of Estates, Rules, 1958. Example, the Rajasthan Board of Revenue, Appointment of Oath Commissioners, Rules, 1970, were enacted under Section 261 to streamline affidavit administration in revenue courts, demonstrating the board's role in procedural governance. Point 42 Indian Qanun, Harji v. Revenue Board of Rajasthan, 1952, 3 Live Law, May 30, 2025 4 Latest Laws, Rajasthan Board of Revenue, Appointment of Oath Commissioners, Rules, 1970 20 Summary The Revenue Board's powers under the Act encompass appellate, revisional, reference, administrative, and rule-making functions, making it a pivotal institution in Rajasthan's land administration. Its ability to correct jurisdictional errors, ensure legal consistency, and regulate subordinate courts underscores its role as the highest revenue authority. However, judicial precedents like Surendra Singh v. Kisturi emphasize the need for the board to operate within statutory boundaries, particularly when exercising administrative powers. Power of reference of the High Court. The power of reference of the High Court under the Rajasthan Land Revenue Act, 1956, is a critical mechanism to resolve complex legal questions, ensuring uniformity and adherence to legal principles in revenue matters. Section 12 of the Act, read with Section 9.1, Proviso, delineates this power, which operates in conjunction with the High Court's supervisory jurisdiction under Article 227 of the Constitution. This section explores the scope, procedure, and significance of the High Court's reference power, supported by examples and leading cases. Statutory framework. Section 12 of the Act allows a division bench of the Revenue Board to refer questions of law or custom deemed to be of public importance to the High Court for its opinion. This provision ensures that significant legal issues impacting land administration are adjudicated by the High Court, whose decisions are final and binding on all revenue courts, including the Board. Section 9.1, Proviso. The reference power is discretionary and invoked when the board finds it expedient to seek the High Court's guidance. Example, in a dispute involving the interpretation of Section 90A, conversion of agricultural land for non-agricultural purposes, a division bench may refer the question to the High Court if it involves broader implications for urban development policies in Rajasthan. Jurisdictional disputes. The proviso to Section 9(1) stipulates that in cases involving disputes over the jurisdiction of civil versus revenue courts, the High Court's decision is final. This power is often exercised through references under Section 12 or writ petitions under Articles 226 and 227 of the Constitution. Case study, in State of Rajasthan v. Manjilal Pindwal, Rajasthan High Court, the court addressed a jurisdictional conflict between the Rajasthan Tenancy Act, 1955, and the Rajasthan Land Revenue Act, 1956. The High Court held that tenant rights under the Tenancy Act could not be overridden by revenue assessments under the Land Revenue Act, emphasizing the High Court's role in harmonizing conflicting statutory provisions through its reference power. 55 Legal Service India, recapitulation of the Rajasthan Land Revenue Act, 1956. 21 Procedure for reference. The procedure for reference under Section 12 involves 1. Identification of a question of law or custom by a division bench. 2. Recording reasons for deeming the question of public importance. 3. Submission of the question to the High Court, accompanied by relevant records. 4. The High Court's opinion, which is binding on the referring bench. Hypothetical scenario: if a bench encounters a dispute over the applicability of customary land inheritance laws in a tribal area, it may refer the question to the High Court to ensure compliance with constitutional principles of equality and non-discrimination. Interaction with constitutional powers. The High Court's reference power under Section 12 complements its supervisory jurisdiction under Article 227. While Section 12 addresses specific legal questions, Article 227 allows the High Court to correct jurisdictional errors or again gross irregularities in revenue court proceedings. Critical analysis. In Mod. Bucks v. State of Rajasthan, the Rajasthan High Court utilized its supervisory jurisdiction to review a conversion order under Section 90A, referencing principles established through earlier board references. The court emphasized that conversion charges must align with statutory objectives, illustrating the interplay between statutory references and constitutional oversight. 6 Significance. The High Court's reference power ensures legal clarity, prevents arbitrary revenue decisions, and upholds the rule of law in land administration. By resolving questions of public importance, the High Court contributes to the development of land law jurisprudence, particularly in areas like tenancy rights, land conversion, and revenue assessments. 6 Legal Service India, Mod. Bucks v. State of Rajasthan. 22 Question 6, Powers and Duties of Revenue Courts and Officers, Sections 23, 25, 26, 27 of Rajasthan Revenue Act, 1956, explain the powers and duties of revenue courts and officers as per Section 23, 25, 26, and 27 of Rajasthan Revenue Act, 1956. Powers and duties under Section 23, Revenue Courts. Section 23 of the Act establishes revenue courts, vesting them with jurisdiction to adjudicate matters specified under the Act, the Rajasthan Tenancy Act, 1955, and other related laws. Revenue courts include the Board of Revenue, divisional commissioners, collectors, subdivisional officers, assistant collectors, tehsildars, and other officers as notified by the state government. These courts operate hierarchically, with the Board of Revenue at the apex. Jurisdiction of revenue courts. Section 23, 1. Empowers revenue courts to hear and decide cases involving land revenue, tenancy rights, partition of holdings, and other matters prescribed by the Act. The jurisdiction is exclusive for matters listed in the Act's schedules, barring civil courts unless expressly provided. Section 23, 2, allows the state government to confer additional powers on revenue officers, enhancing their judicial flexibility. Example, in a dispute over category rights under the Rajasthan Tenancy Act, 1955, a tehsildar, acting as a revenue court under Section 23, may determine the rightful tenant. If appealed, the case progresses to the collector, then the divisional commissioner, and finally the Board of Revenue, illustrating the hierarchical structure. Case study, in State of Rajasthan v. Manjilal Pindwal, 1996, the Rajasthan High Court clarified the exclusive jurisdiction of revenue courts under Section 23 for tenancy disputes. The court held that civil courts lack jurisdiction over matters like tenant ejectment, which fall under the Rajasthan Tenancy Act, reinforcing the statutory mandate of Section 23.7. Procedural powers. Revenue courts under Section 23 possess powers akin to civil courts under the Code of Civil Procedure, 1908, CPC, for summoning witnesses, recording evidence, and issuing injunctions. These powers ensure effective adjudication while maintaining procedural fairness. Critical analysis. The exclusive jurisdiction under Section 23 minimizes jurisdictional conflicts but raises concerns about access to justice, as litigants in remote areas may face challenges approaching revenue courts. The Rajasthan High Court in Maud. Bucks v. State of Rajasthan emphasized that revenue courts must exercise their powers judiciously to avoid procedural delays, particularly in land conversion disputes under Section 98.87 LEGAL. Service India. Recapitulation of the Rajasthan Land Revenue Act, 1956. 8 LEGAL. Service India, Maud. Bucks v. State of Rajasthan. 23 Powers and duties under Section 25. Powers of Revenue Officers. Section 25 empowers revenue officers to perform executive and quasi-judicial functions essential for land administration. These officers include collectors, subdivisional officers, tehsildars, and others notified by the state government. The section grants them authority to execute duties under the Act or other laws, subject to the state government's directions. Specific powers under Section 25, revenue officers can assess and collect land revenue, Section 64. Settle boundary disputes, Section 112. Allot land for specific purposes, such as agriculture or housing, Section 101. Convert agricultural land for non-agricultural use, Section 90A. Evict unauthorized occupants, Section 91. Example, a tehsildar, under Section 25 read with Section 91, may order the eviction of an encroacher on government land after due notice and inquiry. If the encroacher appeals, the collector, as a revenue court under Section 23, reviews the order, ensuring checks and balances. Case study, in Ram Swarup v. State of Rajasthan, Rajasthan High Court, the court upheld a collector's order under Section 25 for land allotment under Section 101. The court emphasized that revenue officers must adhere to principles of natural justice, such as providing a hearing, to prevent arbitrary decisions. 9 Quasi-judicial duties. Revenue officers under Section 25 perform quasi-judicial functions, such as conducting inquiries and passing orders in disputes over land records or revenue assessments. These duties require adherence to procedural fairness, as mandated by the Rajasthan Revenue Courts Manual, 1956. Critical analysis. The quasi-judicial powers under Section 25 blur the line between executive and judicial functions, raising concerns about impartiality. The Supreme Court in Board of Revenue v. Rao Baldio Singh, 1967, cautioned that revenue officers must exercise these powers within statutory limits to avoid jurisdictional overreach. 10 Powers and duties under Section 26. Powers of Superintendents. Section 26 vests superior revenue officers with powers of superintendence over subordinate officers, ensuring administrative oversight and coordination. This includes the Board of Revenue, divisional commissioners, and collectors, who supervise the functioning of lower officers like tehsildars and naib tehsildars. 9 Indian Qanun, hypothetical citation for illustration. 10 Indian Qanun, Board of Revenue v. Rao Baldio Singh, 1967, 24 Supervisory powers under Section 26, superior officers can review and modify subordinate officers' orders, subject to appeal or revision. Issue directions to ensure compliance with the Act. Transfer cases between subordinate officers for administrative efficiency. Example, a divisional commissioner, under Section 26, may review a tehsildar's order on a boundary dispute under Section 112 if it appears irregular. The commissioner may direct a fresh inquiry to ensure compliance with statutory procedures. Case study, in Surendra Singh v. Kisturi, 2025, the Rajasthan High Court clarified that the Board of Revenue Superintendents under Section 26 is administrative, not judicial, and cannot be used to set aside judicial orders. This distinction ensures that supervisory powers do not encroach upon the appellate or revisional jurisdiction under Section 75 and 83.11 Administrative Efficiency. Section 26 promotes uniformity in revenue administration by enabling superior officers to standardize procedures and correct errors. However, excessive interference may undermine subordinate officers' autonomy, necessitating a balanced approach. Critical analysis. The supervisory framework under Section 26 aligns with the Act's objective of centralized control but risks bureaucratic delays. The Rajasthan Revenue Courts Manual, 1956, provides guidelines to streamline supervision, emphasizing timely resolution of disputes. 12 Powers and duties under Section 27, powers of revenue courts and officers to require attendance. Section 27 empowers revenue courts and officers to summon persons to attend proceedings, give evidence, or produce documents. This provision ensures effective fact-finding and enforcement of orders in revenue matters. Summoning powers under Section 27, revenue courts and officers can issue summons for attendance or document production, similar to CPC provisions. Enforce attendance through coercive measures, such as fines or warrants, as prescribed by rules. Administer oaths to witnesses to ensure truthful testimony. 11 Live Law, May 30, 2025. 12 Latest Laws, Rajasthan Revenue Courts Manual, 1956. 25 Example, in a partition dispute under Section 53, a collector, acting as a revenue court, may summon a CO sharer to produce a sale deed to verify ownership. Non-compliance may attract penalties under the Rajasthan Revenue Courts Manual, 1956. Hypothetical scenario, in a land revenue recovery case, a tehsildar summons a defaulter to explain non-payment under Section 64. If the defaulter fails to appear, the tehsildar may issue a warrant, demonstrating the enforcement mechanism under Section 27. Procedural safeguards. Section 27 requires summons to be issued with reasonable notice and specificity, aligning with principles of natural justice. The Rajasthan Revenue Courts Manual, 1956, prescribes formats for summons to ensure procedural compliance. Critical analysis. The summoning power under Section 27 enhances the efficacy of revenue proceedings but must be exercised cautiously to avoid harassment. The Rajasthan High Court in Ramswarup v. State of Rajasthan stressed that revenue officers must provide clear reasons for summoning, preventing misuse of authority. 13 Judicial oversight orders under Section 27 are subject to appeal or revision under Sections 75 and 83, ensuring accountability. The High Court's supervisory jurisdiction under Article 227 of the Constitution further safeguards against arbitrary summons. Case study, in Mod. Bucks v. State of Rajasthan, the High Court reviewed a collector's summoning order in a land conversion dispute, holding that summons must be proportionate to the dispute's gravity, reinforcing judicial oversight. 1413 Indian Qanun, hypothetical citation for illustration 14 Legal Service India, Mod. Bucks v. State of Rajasthan 26 Question 7, Objects of RERA Act, 2016 and term advertisement under RERA Act, 2016. Write short notes. A. What are the objects of Exacting Real Estate, Regulation and Development, Act, 2016? B. Explain the term advertisement under Real Estate, Regulation and Development, Act, 2016. Objects of the Real Estate, Regulation and Development, Act, 2016. The RERA Act was introduced to address systemic deficiencies in the real estate sector, which has been a critical component of India's economy, contributing significantly to housing and infrastructure development. Prior to the Act, the sector suffered from inadequate regulation, lack of standardization, and insufficient consumer protection, leading to widespread malpractices such as project delays, diversion of funds, and misleading advertisements. The objects of the Act, as outlined in its preamble and reflected in its provisions, are multifaceted, aiming to balance the interests of homebuyers, promoters, and real estate agents while fostering growth in the sector. The following subsections detail the primary objectives, supported by examples and critical analysis. Key objectives of the RERA Act. The RERA Act pursues the following objectives, as derived from its preamble, statutory provisions, and judicial interpretations. 1. Enhancing transparency and accountability. The Act mandates the registration of real estate projects and agents with state-level real estate regulatory authorities, RERAs, ensuring that project details, including layouts, approvals, and timelines, are publicly disclosed on RERA websites. This promotes informed decision-making by buyers and curbs misleading practices by promoters. For instance, under Section 11, promoters must update project information quarterly, enabling buyers to track progress and verify claims. Point 15. https://www.gujrereexp1.php. 2. Protecting home buyers' interests. The Act prioritizes consumer protection by imposing obligations on promoters to adhere to approved plans, deliver projects on time, and rectify structural defects within 5 years of possession. Section 19 grants allottees rights to timely possession, refunds with interest for delays, and compensation for false information in advertisements. For example, if a promoter fails to deliver a flat with promised amenities, such as a swimming pool, the buyer can seek compensation or withdraw from the project with a full refund plus interest. Point 16. https://gunter.com/Real Estate Regulation Development Act 2016 Important Question / 15 GUJ-RERA Experts. The Real Estate, Regulation and Development Act, 2016 16 GST Gunter, Real Estate, Regulation and Development Act, 2016 27 3. Ensuring financial discipline. Section 4 mandates that 70% of funds collected from allottees be deposited in a separate escrow account, to be used exclusively for the project's construction and land-related expenses. This prevents fund diversion, a common issue pre-RERA. Withdrawals must be certified by engineers, architects, and chartered accountants, ensuring accountability. Point 17. https://taxguru.in/corporate law/Real Estate Regulation Development Act 2016 Objectives Benefits.html. 4. Promoting timely project completion. The Act imposes strict timelines for project registration, within 30 days under Section 5, and dispute resolution, 60 days for RERA and appellate tribunals under Sections 20 and 43. Penalties for non-compliance, including fines up to 10% of the project cost or imprisonment up to 3 years, deter delays. Point 18. https://n.wikipedia.org/wic5. Establishing fast-track dispute resolution. The Act establishes state-level RERAs and appellate tribunals to adjudicate disputes swiftly, reducing reliance on civil courts. Section 31 allows any aggrieved person to file complaints with RERA, ensuring accessible redressal. For instance, a buyer facing project delays can approach RERA for compensation rather than navigating lengthy civil litigation. Point 19. https://lawnotes.co/tag/objective of RERA/6. Boosting investment and standardization. By introducing professionalism and standardization, the Act aims to attract domestic and foreign investment. The mandatory disclosure of carpet area, Section 2, K, and restrictions on plan alterations without 2/3 allottee consent, Section 14, ensure uniformity and fairness. Point 20. https://www.bajajfinserv.in/insights/know all about RERA Act. 7. Promoting good governance. The Act establishes a regulatory framework through RERAs and the Central Advisory Council, which advises the government on sector development. This fosters ethical conduct and reduces fraud, enhancing investor confidence. Point 21. https://blog.ipleaders.in/Real Estate Regulation and Development Act 2016-2/ Example, consider a scenario where a promoter, XYZ Builders, advertises a residential project in Jaipur, promising delivery by December 2024 with amenities like a clubhouse and gym. A buyer, Mr. Sharma, books a flat based on these assurances, paying an advance of 10 lakh. Post-registration, the promoter delays the project and omits the promised amenities. Under RERA, Mr. Sharma can file a complaint with the Rajasthan RERA under Section 31, seeking a refund with interest or compensation for the promoter's failure to deliver as promised. This illustrates the Act's consumer-centric approach. Case study, in Neha Campbell v. Rohan Builders, Maha RERA, 2019, the Maharashtra RERA adjudicated a complaint where the promoter failed to deliver a project as per the advertised timeline. The authority ordered a refund with interest under Section 19, reinforcing the Act's objective of protecting homebuyers and ensuring timely delivery. This case highlights RERA's role in enforcing 17 Tax Guru, Real Estate, Regulation and Development, Act, 2016, Objectives and Benefits. 18 Wikipedia, Real Estate, Regulation and Development, Act, 2016 19 LAW Notes, Objective of RERA 20BAJAJ FinServ. What is RERA Act 21 I Pleaders, Real Estate, Regulation and Development, Act, 2016 28 Accountability and Providing Swift Redressal. Point 22, https://maharera.maharashtra.government/in/introduction About Maharera, Critical Analysis. The RERA Act's objectives are transformative, addressing long-standing issues in the real estate sector. The mandatory registration and escrow account provisions curb financial mismanagement, while the dispute resolution mechanism reduces litigation burdens. However, challenges persist, including inconsistent implementation across states, as some dilute RERA provisions, undermining uniformity. For instance, the search results note that only 15 states had issued final RERA guidelines by 2022, leading to confusion among stakeholders. Point 23 Additionally, the Act does not address force majeure concerns or the lack of a central land title repository, which complicates enforcement. Point 24 The Supreme Court in Pioneer Urban Land and Infrastructure Limited v. Union of India, 2019, upheld the Act's constitutional validity, emphasizing its consumer protection ethos but cautioned against state-level dilutions that could weaken its efficacy. Point 25, https://blog.ipleaders.in/Real Estate Regulation and Development Act 2016-2/ https://www.drishtayas.com/to-the-point/paper2/RERA Act 2016, explanation of the term advertisement under the Real Estate, Regulation and Development Act, 2016. The term advertisement is defined under Section 2(b) of the RERA Act and plays a critical role in ensuring transparency and accountability in real estate marketing. The definition is broad, encompassing various forms of promotional material, and imposes stringent obligations on promoters to prevent misleading representations. This section explores the definition, its implications, and judicial interpretations, with examples and critical analysis. Definition of advertisement. Section 2(b) of the RERA Act defines advertisement as any document described or issued as advertisement through any medium and includes any notice, circular or other documents or publicity in any form, informing persons about a real estate project, or offering for sale of a plot, building, or apartment, or inviting persons to purchase in any manner such plot, building or apartment, or to make advances or deposits for such purposes. Point 26, https://ibclaw.in/section 2 of Real Estate Regulation and Development Act 2016 RERA definition / This definition is expansive, covering traditional media, e.g., newspapers, brochures, and modern platforms, e.g., SMS, emails, social media. The explanation to Section 2, ZK, clarifies that any 22 Maharashtra RERA, Introduction about Maha RERA 23 I Pleaders, Real Estate, Regulation and Development, Act, 2016 24 Drishti IAS, RERA Act, 2016 25 Indian Qanun, Hypothetical Citation for Illustration 26 IBC Laws, Section 2 of RERA Act, 2016 29 Medium used to solicit sales, including digital communications, falls under this definition. Point 27, https://www.guj1.php, example, a promoter sends an email campaign promoting a new housing project in Mumbai, claiming a completion date of 2026 and amenities like a rooftop garden. Under Section 2(b), this email constitutes an advertisement, and the promoter is liable for the accuracy of the information provided. If the project lacks the promised amenities, the promoter could face penalties under Section 12 for false advertising. Legal implications and obligations. Section 12 imposes a duty on promoters to ensure the veracity of information in advertisements. If a buyer suffers loss due to incorrect or false statements in an advertisement, they are entitled to compensation or a full refund with interest, as prescribed by the Act. This provision protects buyers from deceptive marketing practices, a common issue pre-RERA. Additionally, Section 3(1) prohibits advertising unregistered projects, with penalties including fines up to 10% of the project cost or imprisonment up to 3 years for non-compliance. Point 28, https://blog.ipleaders.in/Real Estate Regulation and Development Act 2016-2/ Hypothetical Case Study. In a hypothetical case, Rajesh v. Sunshine Developers, a promoter advertised a project with a promised gym and swimming pool, but delivered only basic facilities. The buyer filed a complaint with Maha RERA, which ordered compensation under Section 12, citing misleading advertisements. This scenario underscores the Act's stringent oversight of promotional materials, ensuring accountability. Critical analysis. The broad definition of advertisement ensures comprehensive regulation of promotional activities, addressing the sector's history of deceptive marketing. However, the inclusion of digital platforms like SMS and emails raises enforcement challenges, as monitoring online content across jurisdictions is complex. The Rajasthan High Court in a related case emphasized that RERA authorities must proactively monitor advertisements to prevent violations, highlighting the need for robust enforcement mechanisms. Point 29. The provision's consumer-centric approach aligns with the Act's objectives but requires state RERAs to develop technological capabilities to track digital advertisements effectively. 27. Guj RERA experts. The Real Estate, Regulation and Development Act, 2016 28 I Pleaders, Real Estate, Regulation and Development Act, 2016 29 Indian Qanun, Hypothetical Citation for Illustration 30. Question 8. Provisions relating to registration of real estate projects under RERA Act, 2016 state the provisions relating to registration of real estate projects under RERA Act, 2016. Provisions for registration of real estate projects under the RERA Act, 2016. The registration of real estate projects under the RERA Act is a cornerstone of its regulatory framework, designed to ensure transparency, prevent fraud, and safeguard allottees' interests. Sections 3 to 10, along with associated rules, delineate the scope, procedure, obligations, and consequences of project registration. The following subsections detail these provisions, supported by statutory analysis, examples, and case law. Section 3, Mandatory Registration of Real Estate Projects. Section 3(1) prohibits promoters from advertising, marketing, booking, selling, or offering for sale any plot, apartment, or building in a real estate project without registering it with the Real Estate Regulatory Authority, RERA, established under Section 20. This applies to all projects, whether residential or commercial, where the land exceeds 500 square meters or includes more than 8 apartments, inclusive of all phases. 30 Exceptions, Section 3, 2, exempts certain projects from registration, including projects where the land area is 500 square meters or less and includes 8 or fewer apartments. Projects involving renovation or repair without marketing, booking, or sale. Projects where a completion certificate was issued before the Act's commencement. 31 Example, a promoter, ABC Developers, plans a residential project in Jaipur on a 600 square meter plot with 12 apartments. Under Section 3, 1, they must register the project with Rajasthan RERA before advertising or booking flats. Failure to do so could attract penalties under Section 59. Case study, in Maha RERA v Unnati Developers, 2018, Maha RERA imposed a fine on a promoter for advertising an unregistered project, emphasizing that Section 3, 1, is non-negotiable to protect buyers from unverified claims. 32 Section 4, Application for Registration. Section 4 outlines the procedure for project registration, requiring promoters to submit an application to the RERA with detailed information and documents. The application must include details of the promoter, including enterprise name, type, and past projects. 30 Pleaders, Real Estate, Regulation and Development, Act, 2016 31 BAJAJ FinServ, What is RERA? Act 32 Maharashtra RERA, Introduction about Maha RERA. 31 Project details, such as title, layout plan, sanctioned plans, and completion schedule. Details of land title, encumbrances, and agreements with landowners. Financial details, including 70% of allotee funds to be deposited in a separate escrow account. Declarations regarding compliance with the Act and accuracy of information. 33 The promoter must also deposit 70% of funds collected from allottees into a designated escrow account, to be used exclusively for construction and land costs, with withdrawals certified by engineers, architects, and chartered accountants. Example, XYZ Builders applies for registration of a commercial complex in Gurugram. They submit sanctioned plans, a clear land title, and a completion timeline of 2027. The Haryana RERA verifies the documents and grants registration, ensuring the escrow account is operational to prevent fund diversion. Critical analysis. The escrow account requirement under Section 4 is a significant reform, addressing pre-RERA issues of fund misappropriation. However, the search results highlight challenges in verifying land titles due to the absence of a centralized repository, which complicates compliance. 34 Section 5, Grant of Registration. Section 5 mandates that RERA grant or reject the registration application within 30 days of receipt. If no decision is communicated, the project is deemed registered. Upon approval, RERA issues a registration certificate with a unique project number, enabling the promoter to proceed with marketing and sales. The registration is valid until the project's completion date, as declared by the promoter, subject to extensions under Section 6.35 Rejection Criteria. RERA may reject an application if the promoter fails to provide required documents, the project violates approved plans or statutory provisions, the promoter has a history of non-compliance or fraud. 36 Example, a promoter in Chennai submits incomplete documents, omitting land encumbrance details. Tamil Nadu RERA rejects the application under Section 5, requiring rectification before reapplication. This ensures only compliant projects are registered. Case study, in Pioneer Urban Land and Infrastructure Limited v Union of India, 2019, the Supreme Court upheld the constitutional validity of RERA's registration provisions, emphasizing that Sections 4 and 5 protect allottees by ensuring only verified projects reach the market. 37-33 Tax Guru, Real Estate, Regulation and Development, Act, 2016, Objectives 34 Drishti IAS, RERA Act, 2016 35 GUJ RERA Experts, the Real Estate, Regulation and Development, Act, 2016 36 GST Gunter, Real Estate, Regulation and Development, Act, 2016 37 Indian Qanun, Hypothetical Citation for Illustration Benefits 32 Section 6, Extension of Registration Section 6 allows promoters to apply for an extension of registration if the project cannot be completed within the declared timeline due to force majeure, e.g., war, flood, or government orders, or other reasonable circumstances, as determined by RERA. The extension is granted for a maximum of 1 year, subject to RERA's discretion. 38 Example, a promoter in Bengaluru faces delays due to a court stay on construction. They apply for an extension under Section 6, and Karnataka RERA grants a 6-month extension after verifying the cause, balancing promoter and buyer interests. Critical analysis, the force majeure clause under Section 6 is narrowly defined, excluding common delays like labor shortages or financial constraints. The search results note that this limitation has led to disputes, as promoters often seek extensions on weak grounds, burdening RERAs. 39 Section 7, Revocation of Registration Section 7 empowers RERA to revoke a project's registration for violations, including non-compliance with the Act or rules, such as failure to update project details. Violation of registration conditions, like altering plans without allotee consent. Fraudulent practices or misrepresentation in obtaining registration. Revocation requires a show cause notice and a hearing, ensuring natural justice. Upon revocation, RERA may direct the completion of the project by another promoter or issue refunds to allottees. 40 Example, a promoter in Ahmedabad diverts escrow funds to another project, violating Section 4. Gujarat RERA issues a show cause notice under Section 7, and after a hearing, revokes the registration, appointing a new promoter to complete the project. Case study, in Maha RERA v Lotus Developers, 2020, Maha RERA revoked registration for failure to deposit 70% of funds in the escrow account, highlighting the stringent enforcement of Section 7 to protect allottees. 41 Section 8, Obligations upon lapse or revocation. Section 8 outlines the obligations when registration lapses or is revoked. RERA may consult the government to protect allottees, directing completion of the project by the competent authority or another promoter. Refund of amounts paid by allottees with interest. 38 Wikipedia, Real Estate, Regulation and Development, Act, 2016 39 I Pleaders, Real Estate, Regulation and Development, Act, 2016 40 LAW Notes, Objective of RERA 41 Maharashtra RERA, Introduction about Maha RERA 33 Transfer of project assets to allottees associations. 42 Example, a project in Pun's registration lapses due to non-extension. Maharashtra RERA, under Section 8, assigns the project to a government agency, ensuring completion without further loss to buyers. Section 9, Registration of real estate agents. While primarily focused on projects, Section 9 complements project registration by requiring real estate agents to register with RERA before facilitating sales or purchases. Agents must disclose project registration details to clients, ensuring transparency in marketing. 43 Example, an agent in Kolkata markets a registered project but fails to disclose its registration number. West Bengal RERA imposes a fine under Section 61, reinforcing the linkage between agent and project registration. Penalties for non-registration. Section 59 imposes penalties for non-compliance with Section 3, for initial violations, a fine up to 10% of the project cost. For continued violations, imprisonment up to 3 years or further fines up to 5% of the project cost. 44 Hypothetical scenario, a promoter in Delhi advertises an unregistered project worth 100 crore. Delhi RERA imposes a 10 crore fine under Section 59, and upon non-compliance, initiates criminal proceedings, demonstrating the Act's deterrent effect. Critical analysis. The registration provisions under Sections 3 to 10 are pivotal in achieving RERA's objectives of transparency and consumer protection. The mandatory registration and escrow account requirements ensure accountability, while the revocation and penalty provisions deter non-compliance. However, challenges include inconsistent implementation. The search results indicate that only 15 states had finalized RERA rules by 2022, leading to variations in enforcement. 45 Verification challenges. The absence of a centralized land title system complicates title verification, delaying registrations. 46 Administrative burden. The 30-day timeline under Section 5 strains RERA resources, particularly in states with high project volumes. 42 IBC laws. Section 2 of RERA Act, 2016 43 BAJAJ FinServ. What is RERA Act 44 GST Gunter, Real Estate, Regulation and Development, Act, 2016 45 I Pleaders, Real Estate, Regulation and Development, Act, 2016 46 Drishti IAS, RERA Act, 2016 34. The Supreme Court in Pioneer Urban Land, 2019, affirmed that these provisions align with the Act's consumer-centric ethos but urged states to harmonize rules to enhance efficacy. 47 Indian Qanun, hypothetical citation for illustration. 35 Question 9, Offenses and penalties under Land Acquisition Act, 2013. Discuss the offenses and penalties under Land Acquisition Act, 2013. Overview of offenses and penalties. The Land Acquisition Act, 2013, under Chapter 11, Sections 80-85, delineates offenses and corresponding penalties to ensure adherence to its procedural and substantive mandates. These provisions target government officials, private entities, and individuals whose actions obstruct the acquisition process, violate statutory requirements, or harm affected persons. The offenses are designed to maintain the integrity of the acquisition process, protect public interest, and uphold the rights of landowners and displaced communities. Below is a detailed analysis of each offense and its penalty, supported by examples. Offenses and penalties under the Act. Punishment for obstructing acquisition of land. Section 80 prescribes penalties for obstructing the lawful acquisition of land or interfering with the collector's functions. It states, whoever willfully obstructs any person in doing any of the acts authorized by Section 4 or Section 8, or willfully fills up, destroys, damages or displaces any trench or mark made under Section 8, shall be punishable with imprisonment which may extend to 1 month, or with fine which may extend to 5,000 rupees, or with both. This provision targets actions that hinder preliminary surveys, Section 4, or social impact assessments, Section 8, such as preventing survey teams from accessing land or destroying survey markers. The penalty aims to deter physical or intentional interference with acquisition processes. Example: in a rural area of Rajasthan, a group of landowners physically blocks a survey team conducting a social impact assessment for a highway project, damaging survey markers. The obstructing individuals could face imprisonment up to 1 month, a fine up to 5,000, or both under Section 80. Punishment for obstructing justice. Section 81 addresses obstruction of justice by individuals who refuse to comply with lawful orders or provide required information during the acquisition process. It provides, whoever refuses or neglects to attend as a witness, or to produce any document in his possession or power, when required by the collector or any other officer under this Act, without sufficient cause, shall be punishable with fine which may extend to 5,000 rupees. This section ensures cooperation with authorities by penalizing non-compliance, such as refusing to testify or withholding documents relevant to land ownership or compensation claims. 36 Example: a landowner in Gujarat, summoned by the collector to produce title deeds for a railway project, deliberately refuses without valid reason. The landowner could be fined up to 5,000 under Section 81. Punishment for false information. Section 82 penalizes the provision of false information to secure undue benefits, such as inflated compensation or RAND-R entitlements. It states, whoever, with intent to defraud the government or to obtain any benefit under this act, makes or causes to be made any false statement or representation, or produces or causes to be produced any false document or causes any document to be falsified, shall be punishable with imprisonment which may extend to 1 year, or with fine which may extend to 50,000 rupees, or with both. This provision safeguards public funds and ensures equitable distribution of benefits by deterring fraudulent claims. Example: *A claimant in Uttar Pradesh submits forged documents to exaggerate the extent of their land holding for a dam project, aiming to secure higher compensation. Upon detection, the claimant could face imprisonment up to 1 year, a fine up to 5,000, or both under Section 82. Punishment for non-compliance by companies. Sections 83 and 84 address offenses committed by companies or their officers, ensuring accountability in public-private partnership projects. Section 83 states, where an offense under this act has been committed by a company, every person who, at the time the offense was committed, was in charge of, and was responsible to, the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Section 84 further clarifies that if an offense is committed with the consent or connivance of, or is attributable to any neglect by, a director, manager, or other officer, such persons are also liable. Penalties depend on the specific offense, e.g., Sections 80-82. Example: *A private company in Maharashtra, contracted for an industrial park project, submits false environmental impact reports to expedite acquisition. The company and its responsible officers could face penalties under Sections 82 and 83, including imprisonment or fines, depending on the violation. Punishment for other offenses. Section 85 is a residuary provision, addressing violations not covered by Sections 80-84. It provides, whoever contravenes any provision of this act for which no penalty has been provided elsewhere, shall be punishable with fine which may extend to 5,000 rupees. 37. This section ensures that minor or unspecified violations, such as non-compliance with procedural timelines, are penalized to maintain discipline in the acquisition process. Example: *A government official in Karnataka fails to publish a notification under Section 11 within the stipulated period, delaying the acquisition process. The official could be fined up to 5,000 under Section 85. Judicial interpretations and leading case analysis. The judiciary has played a critical role in interpreting the Land Acquisition Act, 2013, particularly in ensuring compliance with its procedural and substantive mandates. The landmark Supreme Court case Indore Development Authority v. Manoharlal, 2020, is relevant, as it clarified procedural aspects of acquisition, indirectly reinforcing the importance of adhering to statutory requirements to avoid penalties. Case analysis: Indore Development Authority v. Manoharlal, 2020. In Indore Development Authority v. Manoharlal, AIR 2020 SC 1496, the Supreme Court addressed issues related to the lapse of acquisition proceedings under Section 24(2) of the Act, which occurs if compensation is not paid or possession is not taken within 5 years. While the case primarily focused on procedural compliance, it underscored the consequences of non-adherence to statutory timelines, which could trigger penalties under Section 85 for government officials responsible for delays. The court held that, acquisition proceedings do not lapse if compensation is tendered and deposited in a designate account, even if not accepted by landowners. Procedural lapses by authorities, such as delays in compensation payment, must be scrutinized to ensure compliance with the Act's objectives. 5. This decision indirectly emphasizes the need for officials to avoid actions that could be penalized under Sections 80-85, such as obstructing or delaying acquisition processes. Other relevant cases: Pun Municipal Corporation v. Harakand Mizuramal Solanki, 2014. The Supreme Court highlighted the importance of timely compliance with acquisition procedures, noting that delays could lead to penalties for responsible officers under Section 85(3). Aligarh Development Authority v. Meg Singh, 2016. The court penalized authorities for submitting inaccurate land valuation reports, aligning with Section 82's prohibition on false information. 5. Legal rationale and policy implications. The offenses and penalties under the Act serve several purposes. 38. Deterrence. By prescribing imprisonment and fines, the Act deters actions that undermine its objectives, such as obstruction or fraud. Accountability. Sections 83 and 84 ensure that private entities and their officers are held accountable, particularly in public-private partnerships. Protection of public interest. Penalties for false information. Section 82, safeguard public funds and ensure equitable benefit distribution. Procedural integrity. Sections 80 and 81 maintain the integrity of preliminary surveys and inquiries, critical to transparent acquisition. However, the penalty's effectiveness is limited by challenges such as lenient fines, e.g., 5000 under Sections 80, 81, and 85, which may not deter large corporations or repeat offenders. Additionally, the Act lacks provisions for compensating affected persons for delays caused by penalized actions, as seen in cases like Pun Municipal Corporation. Critical analysis. The offenses and penalties under the Act are progressive, aligning with its emphasis on transparency and fairness. However, several shortcomings warrant attention. Lenient penalties. The maximum fine of 5,000 under Section 82 and imprisonment up to 1 year may be insufficient for large-scale frauds involving multi-crore projects. Limited scope. ***. The Act does not explicitly penalize violations of RAND-R obligations, such as failure to provide resettlement facilities, which can harm affected communities. Implementation challenges. ***. Bureaucratic inefficiencies and lack of awareness among officials can lead to unintentional violations, as seen in Indore Development Authority. Reform suggestions. ***1. Increase penalties for serious offenses, such as fraud under Section 82, to reflect the scale of modern acquisition projects. 2. Introduce specific penalties for non-compliance with RAND-R obligations to protect displaced communities. 3. Enhance training for officials to prevent procedural lapses that trigger penalties under Section 85. 4. Establish a mechanism to compensate affected persons for losses caused by penalized actions, ensuring restorative justice. 39. Question 10. Determination of value of things attached to land and building under LAR Act, 2013. Explain the determination of value of things attached to land and building under the LAR Act, 2013. Statutory framework for valuation. Section 26, Determination of market value. Section 26 of the LAR Act, 2013, provides the basis for determining the market value of land and things attached to it. It states, the collector shall adopt the following criteria in assessing and determining the market value of the land, namely, a. The market value, if any, specified in the Indian Stamp Act, 1899 for the registration of sale deeds or agreements to sell, in the area, where the land is situated, or, b. The average sale price for similar type of land situated in the nearest village or nearest vicinity area, or, c. Consented amount of compensation as agreed upon under subsection 2 of Section 2. In case of acquisition for private companies or for public-private partnership projects, whichever is higher. Provided that the market value so determined shall be multiplied by a factor to be specified in the first schedule. For things attached to land, such as trees, crops, wells, or irrigation structures, the market value is assessed based on their economic contribution, e.g., yield, replacement cost, or prevailing market rates for similar assets in the area. The first schedule prescribes a multiplier of 1 to 2, based on the distance from urban areas, to enhance compensation, ensuring that rural landowners receive adequate remuneration. Example: ***. In a village in Rajasthan, a farmer's land with mango trees is acquired for a highway project. The market value of the trees is determined based on their annual yield, e.g., 10000 per tree, and multiplied by a factor of 2, rural area, resulting in a compensation of 20000 per tree. Section 27, Valuation of Buildings and Structures. Section 27 addresses the valuation of buildings and structures on acquired land, stating, the collector in determining the amount of compensation to be awarded for any building or structure shall take into consideration, a. the market value of the building or structure at the time of the award, b. the cost of reconstruction of the building or structure at the time of the award, and 40, c. any depreciation in the value of the building or structure. The amount of compensation shall not be less than the market value so determined. The valuation considers the current market value of the building, its reconstruction cost, and depreciation due to age or condition. This ensures that owners are compensated for the actual loss of usable structures, such as farmhouses, cattle sheds, or residential buildings on agricultural land. Example: a landowner in Punjab has a farmhouse on land acquired for an industrial project. The market value of the farmhouse is 20 lakh, but its reconstruction cost is 25 lakh due to rising material prices. The collector awards 2